So we are going to talk case study 8, Franklin v. Goodnight County. So the case is about Franklin right here. So Franklin is a plaintiff and the defendant is Goodnight County Public Schools and William Prescott. So So I'm going to talk about how to find case volume and page number. So the number at the front of the U.S. and the Supreme Court and Law Edition is all the reporter, and the U.S. is official reporter, and Supreme Court Law Edition is the unofficial reporter. So the 503 and 112 and 117 are the volume number, and 60 and 1028 and 208 are the page number, and the 1992 is the year of the case. So next, I'm like my group member Johnson to talk about.
All right. The law of action for damages in the federal court under Title IX of the Education Amendment of 1972. Damages against Gwinnett Public Schools, saying that she had been intentionally discriminated against because of her gender. Gwinnett filed a motion to dismiss, stating that compensatory relief is unavailable for violation of Title IX. The court deposition, she stated that their discussions were sexual in nature, and the other teachers were told and made aware about the discussions and what was going on. Franklin was dismissed from classes and had arguments in the parking lot with Mr. Hill, where he occasionally grabbed and kissed her. She reported that they had sexual intercourses on school grounds, and the staff of the school dismissed her reports and discouraged her of making the report.
Page.
The federal courts have the power to award any appropriate relief and cognizable cause of action brought pursuant to the federal statute. And according to the Supreme Court, Title IX, United States Courts of Appeal for the 11th Circuit affirmed the district court's dismissal on the grounds that Title IX did not authorize an award of damages. The school district argued that Title IX only provided equitable relief. The Supreme Court reversed the judgment and remanded the case. The court ruled that one, Title IX provided a damage remedy for students because the court presumed the availability of all appropriate remedies unless the United States Congress had expressly indicated otherwise. And two, where liability was created by statute without a remedy, it would have been enforced by a common law action.
All right, I'll take over. So according to the Supreme Court, do federal courts have too much power in deciding a remedy for a plaintiff bringing suit under Title IX? And what's our opinion? We said no, they don't have too much power, and we believe federal courts have an appropriate amount of power in deciding remedies, bringing suit under Title IX. And we can go ahead to compare and contrast equitable remedies with monetary damages. So a remedy is a type of compensation given to someone through a legal proceeding, and equitable remedies are specific categories of remedies that can be obtained in a breach of contract situation. They are actions the court prescribes which will serve to resolve the breach or dispute, and they're non-monetary solutions to resolve the disputed issue and are typically granted when legal remedies or monetary compensation cannot adequately resolve the wrongdoing. Legal remedies allow the non-breaching party to recover monetary damages, which are types of damages designed to compensate the plaintiff for the harm that has been done. These can include damages such as compensatory damages, lost profits, punitive damages, lost wages, expectation damages, and restitutionary damages. And what equitable remedies did the defendant want the plaintiff to receive in place of monetary damages? So in this case, the defendant wanted the plaintiff to receive equitable remedies of back pay, which is lost earnings that the victim would have received absent discrimination, and prospective relief, which is all relief other than compensatory monetary damages. And those remedies were not appropriate in this case because the plaintiff was a student when the alleged discrimination occurred. The teacher no longer teaches at that school, and the plaintiff no longer attends a school in the Gwinnett County system.